Bienvenue dans notre cycle annuel de conférences sur la recherche en droit. Mon nom est Margarita Garcia. Il me fait vraiment très plaisir de vous accueillir. Je suis la vice-doyenne à la recherche à la section de droit civil. Et aujourd'hui, nous avons l'honneur de recevoir Maître Mary Birdsell, avocate, directrice générale du Centre for Youth and Children and Youth, actually. Je dois vous dire que c'est un effort collaboratif entre la section de droit civil, le laboratoire de recherche interdisciplinaire sur les droits des enfants et le département de criminologie dans le contexte des célébrations de son 50e anniversaire. Et donc, j'ai ici avec nous pour vous présenter notre invité spécial, ma collègue Mona Paré et notre collègue Christine Gervais du département de criminologie. Donc, je vais leur céder la parole et je vous souhaite à toutes et à tous une belle conférence.
Bonjour à tous, bienvenue, good morning and welcome. This is, as Margarita said, a collaborative effort. This is the first event of the Interdisciplinary Research Laboratory on the Rights of the Child, which is housed here within the Civil Law section, but which has members all over the university. And we organize this kind of noon lectures, as well as a yearly conference. And today's noon lecture is actually a follow-up of our last yearly conference that was on children's rights and the legalization of cannabis. So now that we are getting much closer to the legalization, we have here Mary Birdsell, Director of Justice for Children and Youth, who will talk about the implications. And I will pass on the floor right away to my colleague, Christine Gervais, who's professor at the Department of Criminology and who will present our speaker.
So good morning, everyone. Mon nom est Christine Gervais, professeur en criminologie et membre du laboratoire. We begin by acknowledging that the land on which we gather is a traditional unceded Algonquin territory. Given the continued marginalization of Indigenous peoples in Canada, we in the Department of Criminology commit ourselves to the work of reconciliation and decolonization. We hope that this event and others this week that we have organized help to contribute to this necessary work. Donc, bienvenue à la première conférence midi de l'année du laboratoire de recherche interdisciplinaire sur les droits de l'enfant et la deuxième conférence midi présentée dans le cadre du cycle annuel de conférences sur la recherche en droit de la section de droit civil en collaboration avec le département qui célèbre notre 50e anniversaire. Et on reconnaît le soutien du Bureau de la recherche de la section de droit civil et de la vice-doyenne à la recherche et aux communications, Margarita Garcia, qui est aussi professeure agrégée en criminologie. So welcome to the first noon-hour lecture hosted by the Interdisciplinary Research Laboratory on the Rights of the Child in this new academic year, and the second noon lecture is part of the annual lecture series on research and law in the Civil Law section of the Faculty of Law, in collaboration with the Department of Criminology, which is celebrating its 50th anniversary. We acknowledge the support of the Research Office of the Civil Law section of the Faculty of Law and the Vice Dean Research Communication, Margarita Garcia, who is also an Associate Professor in Criminology. On remercie aussi Lynn Bissonnette, Lucie Gravel, Sophie Fréchette et Marianne Burgess pour leur soutien administratif exceptionnel qui nous a permis d'organiser cet événement aujourd'hui, incluant la pizza. The Interdisciplinary Research Laboratory on the Rights of the Child was created in 2007. It's affiliated with the Faculty of Law and the Human Rights Research and Education Center here in the Faculty of Law. Its mandate is to promote interdisciplinary research and collaboration in the area of children's rights with the goal of contributing to better protection on the rights of the child, both nationally and internationally. And it is within this mandate that we host this presentation on the child rights implications of the legalization and regulation of cannabis in order to explore the priorities and tensions between protection on the one hand and agency on the other. We are grateful to Mary Birdsell for her willingness to enlighten us on these important matters today. Mary Birdsell is the Executive Director, as you know already, at Justice for Children and Youth, a legal clinic in Toronto specializing in child and youth rights in Ontario. She has been a staff lawyer and community development lawyer at Justice for Children and Youth since she was called to the bar in Ontario in 1996. Ms. Birdsell has been active in all areas of the clinic's work: direct representation of young people, especially highly vulnerable young people with complex needs and experiences, public legal education, community development, and systemic law reform work. She has been counsel at every level of court, including the Supreme Court of Canada. Ms. Birdsell was involved in the creation of the mental health diversion programs in the local youth court and was counsel to Empowerment Council at the inquest into the death of Ashley Smith. Ms. Birdsell has extensive experience in public legal education, continuing professional development, and training about the law as it affects young people and their rights in schools, community settings, institutional settings, including custodial facilities. She speaks at local, national, and international conferences. Ms. Birdsell has worked internationally with the CBA on child rights and child representation development in East Africa and Malaysia. Recently, she co-authored extensive submissions regarding Ontario's newly established child welfare legislation and submissions regarding the practice of holding children in immigration detention centres. We will surely be enlightened by such extensive expertise today, so please join me in welcoming Mary Birdsell.
Well, thank you very, very much for having me join you today. I really appreciate the opportunity. I'm happy to have the opportunity to talk about children's rights generally, and specifically to talk about them in the context of the new cannabis legislation in Canada and in Ontario. I want to go through my slide presentation and the contents of it. I'm going to talk a little bit about justice for children and youth and a little bit about sort of a framework for thinking about children's rights in the context that we think about it in our office and in the broader context of children's rights academia. And then I want to talk a little bit about the legislation, federal and provincial legislation, and then talk about what we consider to be problematic, in particular in the context of the federal legislation. I think that probably the most helpful thing or useful thing for us to do in terms of a discussion today is to have you ask questions as we go along. And if we don't have time to cover all the questions as they come up, I encourage you to please write them down or make sure that you remember, and I will also leave a little bit of time at the end to make sure that we can have a pretty comprehensive discussion, or at least as comprehensive as possible in a noon hour. So can I ask some people, how many people are in the Faculty of Law? And how many people in the criminology faculty? Okay. And how many people are here specifically because they're interested or working in children's rights? Oh, well, so I'm hopeful that we can change that by the end. Everybody will be interested. All right. So we will get started. So Justice for Children and Youth, as has been mentioned, is a specialty legal clinic. We have a provincial mandate, but we also are involved at a federal level in the sense that we, especially in the context of youth criminal justice, because it has a national impact. We provide legal services to people under the age of 18 and to those under 25 if they are homeless or at serious risk of homelessness. Justice for Children and Youth is one of 70-odd legal clinics in the province of Ontario. So I'm not sure if you know, but Ontario is extremely well-resourced, ironically, in the context of legal clinics. We have an internationally renowned body of lawyers who, or our model of providing clinical legal services, which are poverty law services, lawyers who provide legal services to people who experience poverty in particular kinds of areas, that really is a model around the world for how you might do that in a comprehensive way. And the clinics focus not only on assisting individual clients, but they focus on systemic kinds of issues. So their goal is not just to help an individual person who has income security issues, but their focus is to try and make sure that income security issues for people across the province are better addressed. There's a little bit of information about Justice for Children itself. We are what's called a specialty legal clinic. So although we're located in Toronto, we have a provincial mandate and we provide services to children across the province. That's a little screenshot from our website, and I encourage you to go there, both for substantive content about children's rights and legal issues, and also, I hope, for resources and just curiosity. So, children's rights, what are they? And one of the things that I will say, and that I have said before and will probably say again, is that I actually think in today's world, children's rights are one of the last areas of rights assertion that still meets with some fundamental opposition. And it's a complex issue, but I think it sort of stems from this idea that children as babies require us to do everything for them. And moving forward to adulthood is a complex navigation of respecting the rights of those individual children and providing care and guidance to them without treating them like property. All right? So, you know, a simplistic sort of view of that is that we talk about, oh, that's my child, or these are our children. So I know what the right thing to do is, so I make decisions on their behalf. And I think that all of us can appreciate, because we've all been children at one point, that at some stages of our lives, there are things that we expect other people to make decisions for us about, things about which, and as we get older and we grow, we want to make more autonomous decisions and have more control over our own context and environment. And the thing that's challenging about children's rights is getting adults to think about those children right from the get-go as individual rights holders for whom we can act as sort of stewards and supporters, but for whom we ought not to assume we are the controllers, if that makes sense. So what we say is that children are entitled to recognition of their rights and respect for their inherent human dignity as individuals. So you don't start off as a baby as being my possession, you know, and this being for whom there are no rights or anything that's just property, and carry forward as I've said. One of the important things about children not being property is that they don't and ought not to have to earn their access to rights. So, for instance, exercising your right to participate in decision making or to be treated with dignity is not a matter of a reward for good behavior, or because you have jumped through a number of hoops and sort of met the preliminary criteria, so that we then say, oh, all right, now that you're behaving well, we'll give you rights. That's not how it's meant to work. And the other thing, and we're probably not going to have time to talk about this, although this is very interesting to me, that human rights are inherent, interrelated, interdependent, and indivisible. And this kind of commentary, if you're interested in reading more about it and learning more about it, in the United Nations Convention on the Rights of the Child, if you go to the UNHCR website, look at the document called the United Nations Convention on the Rights of the Child, which is sort of the document on which we build our theoretical structures or approach. There are many sources there, many resources, including general comments. And there's a lot of discussion about the ways in which rights are interrelated, interdependent, and indivisible. So, for instance, it means that you know, protecting you from harm, protecting children from harm, can't be separated from children's right to participate in decisions that affect them. All right, so you don't say on the one hand, well, I'm protecting you from harm, so you just sit quietly and I'll let you know what's going to happen. And then on the other hand say, oh, would you like to participate in decisions that affect you, participate meaningfully? You have to do all of those things in an integrated way. So I provide this, it's not related to cannabis necessarily in a really direct way, but it is related to the approach we take to legislation generally, and cannabis is included in that. The other thing that's really important for us at our office is working in an anti-oppression framework. So this is sort of, you know, includes many, many different things. What I've listed there are sort of key and important children's rights notions. But of course, you will also be aware in your personal lives and from your academic context that you know, the anti-oppression forces that are at play are variable and substantial for all children. And in my experience, especially children who are experiencing poverty, who may be experiencing racism, you know, other issues related to their gender identity and sexual expression. You know, indigeneity is obviously a very significant factor in Canada and something that we continue to struggle with. Sexism is also at play in many legal contexts for teenage girls especially. Does anybody have any questions or want to say anything about sort of a children's rights framework? That's like the 101 done in a terribly negligent way probably, but I just wanted to lay some of the fundamental thoughts out. Does anybody want to talk about that anymore? All right, cannabis legislation. So the big question is, why are we implementing cannabis legislation? And there's another slide that I'll come to in a minute, but the thing I want to say, and I want to repeat it, is that cannabis, in my opinion, has not been decriminalized and it has not been legalized. So although that's the language that gets used in the public discourse, I think it's problematic, especially for teenagers. Anyway, the why. What do we say? Well, we want to decriminalize cannabis to limit harm, especially harm occasioned by the underground drug trade. And I'm not going to go into the kinds of harms that exist there, but there are social harms, economic harms, personal harms, and societal harms. That's different from social. And then we want to regulate use so that we have some kind of consistency going on in terms of how we think of cannabis and how we treat it. There is a discourse for certain, and it's evident in the law, and we'll talk about this in a minute, about a special focus on harms occasioned by teenagers. And we're going to come to this a little bit more, but I want you to have in your mind at some point the difference or the similarity or the ways that the questions intersect around harms that we're trying to limit, like the underground drug trade, and individual harms to teenagers, when I'm going to suggest to you that these are sort of at odds with each other in a strange way. So we know that we understand that as teenagers have developing brains and that brains continue to develop into adulthood, you know, a psychotropic actor like THC or that's found in cannabis, you know, has an impact on those brains, and there's other science. So we want to limit their use because it's bad for teenagers, and so we're looking into criminalization and regulation. So how many people sort of understand the distinction between the federal law and the provincial regulation of cannabis? So people have a little bit of an understanding. So the federal legislation comes from the criminal law power, and it is related entirely to criminal charges, criminal prosecutions, and criminal sanctions. And currently, up until less than a month, a few weeks from now, cannabis is a controlled drug and substance that is illegal. That is to say that having possession of it, sharing it, growing it, selling it, all these things are criminally illegal. You can get charged by the police, go to criminal court, and if you're a young person, wind up with a youth court record, or if you're an adult, wind up with a criminal record. As of October the 17th, there are massive changes to that criminal law structure. So the federal law is called an Act Respecting Cannabis and to amend the Controlled Drugs and Substances Act, the Criminal Code, and other acts. It was received royal assent in June, and it comes into force on the 17th. And it's called the Cannabis Act. So, in a first tier of confusion, the provincial legislation is also called the Cannabis Act, and it was passed in December and comes into force on the same day as the federal legislation. So what you may, the sort of easiest way to articulate it, and this is borne out in Ontario, is that the provincial legislation is about regulating how cannabis exists in Ontario. Each province and territory does this in their own way, and so there's variation across the provinces and territories. So what happens in Ontario will be different than what happens in Quebec and different than what happens in Manitoba, etc. So this is what I said earlier, that there are criminal sanctions that remain. So for instance, if you are over 18, and we'll talk more about this, you can be charged criminally if you have in your personal possession more than 30 grams. And there are all sorts of other things that remain criminally, where you can be charged criminally. There are criminal sanctions for violating the criminal law as it relates to cannabis. So there continue to be criminal law effects around cannabis, but it's much, much different, and there's much greater access now than there used to be. I also would say that it's not legalized because there are extensive regulations that remain. Now, having said that, you know, if we think about, for instance, you know, Coca-Cola, I think we would all say that Coca-Cola is a legal substance, and of course that's true. That's not to say that there aren't regulations. There are Food and Drug Administration regulations, quality controls, and other kinds of things that exist for all food products, in fact. So, you know, saying it's not legalized is maybe a little bit provocative, but I'm going to come back to why I think it's important to say that. But it is important to know that there are many restrictions on cannabis in the province of Ontario. And what Ontario has chosen to do is essentially to mirror the law that exists for alcohol and tobacco. So generally speaking, if you wanted to have some one thing that you take away and remember, is that cannabis, alcohol, and tobacco all have similar rules in terms of teenage access to those products. I didn't know this, but I just heard in the news a few days ago that Quebec is going to make the access age 21, which is very interesting to me, and I don't know very much about it, I apologize, but it's very interesting to me that Quebec is taking this more restrictive approach to cannabis than they have to alcohol, and whereas there are other provinces who have fairly rigid restrictions around alcohol and cannabis. So we can get into that if people want to. So I wanted to just set out quickly a little bit about the regime for young people. And again, there are some important things here. Any young person, so any person 17 and younger, is going to be dealt with in the criminal law context under the Youth Criminal Justice Act. How many people are familiar with the Youth Criminal Justice Act? Okay, so it's the law that essentially provides structure, process, and special considerations that apply to teenagers in the criminal justice system. So the laws themselves aren't different, right? Assault is against the law, theft is against the law, possession of controlled drugs and substances is against the law, et cetera, you get that. You can be charged criminally for offending the criminal law. But if you are 12 to 17, you will be dealt with according to the Youth Criminal Justice Act. So it sets up, it's an entire regime in Canada, and we could have a noon-hour session on that too, but it sets up a unique approach to dealing with teenagers in the criminal justice system, an approach that focuses on rehabilitation, reintegration, and addressing the underlying needs of the offending behavior in recognition that teenagers are in a unique phase of development, that they have a reduced maturity, and what the law says is a reduced moral culpability for their criminal law behavior. Okay? And then the rest of it is just that there are federal sanctions under the Cannabis Act, and there are lots of regulations. So one of the reasons that I have already sort of highlighted and we're going to continue to talk about is the problem about the confusing and sort of complicated web of legislation that now is going to exist for criminal law, or for cannabis, pardon me. Especially given that teenagers sometimes are pretty concrete in their thinking. They want to know, is it legal? Is it not legal? And if we are all saying in the body politic that cannabis is now legal, then cannabis is legal. Let's go for it. So one of our concerns as public legal educators at Justice for Children and Youth is to try and get the message out there to teenagers that, don't get too overexcited, because there are still a bunch of laws that are going to restrict your use and access, and you can still meet both criminal law sanctions and provincial sort of ticket-like offenses, and we'll talk more about that. And the other thing is that as a lawyer and a person who's interested, or a lawyer who's interested in criminal... oh dear, I'm sorry, I think that might be me, and I will turn it... I tried to turn it off before. The question about how the federal government has chosen to deal with criminal law sanctions for teenagers is problematic. Oh, everybody's phone's going to ring. That makes me feel less badly. So, one of the things that we say, or what that we say are problematic about the federal legislation is that it's confused and has a slightly conflicting approach to the provincial legislation. We think there are misplaced objectives. We think that there's a potential to exacerbate discriminatory impacts and effects, and that the federal law is in fact discriminatory on its face, and further that it's probably ineffective as it's drafted. So this is just a slide to give you a little bit more context around the Youth Criminal Justice Act, but I've already talked about it. Here's some of the key provisions that exist in the Youth Criminal Justice Act, and I'm laying them out here because I'm going to come back to highlighting where I think there are some inconsistencies in the legislation. So, societal responsibility for young people, recognize unique developmental needs, preventing youth crime by addressing underlying issues, special guarantees of rights, meaningful accountability, meaning meaningful for the individual, so that the young person is sort of, you take into account their unique circumstances and possible differences and whatnot, so that you don't just fashion cookie cutter responses, you fashion very individually tailored responses, and the promotion of rehabilitation reintegration. So I wanted to just include a couple of things that the Supreme Court of Canada has said about the Youth Criminal Justice Act and its approach to young people, highlighting special guarantees and the significance of the United Nations Convention on the Rights of the Child being part of the Youth Criminal Justice Act. It's in the preamble, and that's significant in I'm going to go off on a big tangent here. The UNCRC has just been incorporated into the new Child, Youth and Family Services Act, the Children's Aid legislation, and I think that's significant as well. The court has recognized the significance of reduced moral culpability as a constitutionally significant piece of part of the legislation, and that the special provisions that exist to guard against stigma and labeling also have constitutional significance and are a significant part of that legislation. So, I want to move to talking about the Federal Cannabis Act. Does anybody have any questions that come up about youth criminal justice or some fundamental questions about the federal versus provincial legislation? No? All right, I'll carry on then. I don't even have time to drink my water. So the big thing I will say about the Federal Act, and we're going to come to it, but is that the big things that I think are significant to young people in particular are the rules around possession, sharing, and acquisition, or purchasing and selling, and possibly young people will care about growing cannabis. And the big distinction between those who are under 18 and those who are over 18 is that 17-year-olds and younger can have in their personal possession up to 5 grams of cannabis. Adults, people who are 18 years old and older, can have up to 30 grams of cannabis in their personal possession. And there are a number of other things that we're going to look at. But that's the big, because that's what most, and we're going to come to this a little bit more too, but most criminal law involvement with cannabis, especially on teenagers, is around the possession, simple possession of cannabis, all right? So, according to the criminal law, if you are, yes? Well, that's the good question. Sorry, if I understand properly, the question is how much is 5 grams? Like when you're looking at how many joints is that? Is that sort of the question? So it depends whether, nobody's going to get this cultural reference unless you're my age, but does anybody know who Cheech and Chong are? Oh yeah, okay, so everybody gets it. So if you're Cheech and Chong, that might only be 1 or 2 joints. If you're not Cheech and Chong, it might be as many as 5. Okay? So it's, a bit, but it's not a ton. And if you're very frugal, it might be 10. But that's the sort of range of does anybody disagree with me about that? You do?
Yeah, most likely. What I say to judges ask me, because I'm a criminal law lawyer,
yeah.
and they normally ask how much is 5 5 grams. It's common. It always depends on the enthusiasm of the person that roll it. But most likely, when they seize quantity, normally it's about 0.25, 0.3 per joint. So
Could be 2 joints.
yeah. A gram could be 4 joints.
Yeah. Okay. So that my Cheech and Chong reference was meant to address the enthusiasm of the roller, but so you would suggest, you think that 5 grams could be as many as 20 joints.
Exactly.
Okay. All right. So thank you for educating me and all of us about that. So you can also see that for adults, having up to 30 grams, that's a fairly significant amount of cannabis to be allowed to have on your person. So it really is a radical change from 0 to up to 30 grams. And do people in law school still talk about the Keith Richards defense to possession for the purposes of trafficking? I don't know. So when I went to law school, they used to talk about the Keith Richards defense because you could be charged for possession for the purposes of trafficking if you had a lot of pot on you. But Keith Richards got arrested in Toronto in the 70s, and he had a lot of pot on him. And he said, "It's not for sale. I have a substantial personal habit." So the 30 grams thing is sort of addressing this substantial personal habit. The other thing that's sort of funny about it, but it's important to think about in terms of how this is practically going to play itself out, is very few people are going to carry 30 grams around with them, like on their way to the corner store or on their way to meet their friend for coffee, right? If you're carrying it around, you're probably not going to have, unless you're going, you know, on a big holiday with a lot of people or something like that. So the question is kind of like, where is this going to happen? Where are the police going to find you with 30 grams, or if you're a teenager, up to 5 grams? And how, you know, how is that going to come to light? Are they going to be finding it in your home? All these kinds of questions. So I leave that to you as a bigger issue. I wanted to start with the Federal Cannabis Act and its purpose, because this is what the law says is its purpose. And those of you who are at law school, and maybe those of you who are in criminology, will know that, you know, this can take up importance when you're in the court wondering, you know, some question about how the law is being used. And so you're partly going to look at the purpose as it's written down in the law, and you're also going to look at everything that got said in the media, in the parliamentary debates, all of that kind of stuff. But what the law says, especially as it relates to young people, is that we want to protect the health of young persons by restricting access to cannabis. So I'm going to leave as an open question to you whether protecting health is a reasonable criminal law, the use of a reasonable criminal law power. Are there any other contexts where we protect health through the criminal law? The other purposes include reducing the burden on the criminal justice system, providing access to a quality-controlled supply, and enhance public awareness of health risks. Here's where some of the meat exists in Section 8 and 9 of the Act. I might take a pause and say that I've been involved in a number of different discussions as the legislation was being evolved with people, and the Federal Cannabis Act is huge and contains an incredible amount of stuff around like growing and propagation and transport, and, you know, is related to licensing and business and all sorts of things that I know very, very little about. What I know about is the sort of the parts of it, the limited parts of it that deal with issues that young people are going to encounter. So we've already talked about the criminal liability for possession. One of the things in the federal law is that it's prohibited for somebody over 18 to distribute to someone under the age of 18. So distribute is going to include, I would suggest, things like sharing. So if you're in high school and you are smoking a joint, and you're 18 and you're smoking a joint with your friend who's 17, it will be criminally illegal for you to pass it over and do that distribution. Okay? So that's just a highlight of one of those things. Under 18-year-olds are prohibited from distributing among themselves even, and sentencing is governed by the YCJ, which we've already known. One of the things that has come up, and this is a detail that will maybe make more sense later, is that when the federal government is justifying the difference in the way they treat adults and teenagers, they say, oh, but don't worry, the teenagers will be dealt with under the Youth Criminal Justice Act. But that's sort of slim comfort because that's where they always get dealt with. So they haven't added anything protective. They're just telling us how the system works, which is, of course, how the system works. So production, I included this slide, although I wasn't going to talk about it too much, but it's prohibited for anybody to cultivate, propagate, or harvest, or offer to do those things, plant or material that is illicit. And I sort of included this because, you know, it makes it clear that there continue to be illicit things in the context even of cannabis, and that's found in the regulations, and the truth is I don't know that much about those distinctions, those fine distinctions either. But the big one is the more than 4 plants at one time in a dwelling house. So in a dwelling house you can have 4 plants. And just as a comical piece of information about the plant situation, there used to be a bunch of parts of it that included how high it could be and how big it could be, and I think they decided that that was just going to be impossible to regulate criminally. So let's just call it plants and leave it at that. So if you've got good fertilizer, you might have big plants. If you have lousy light, you might not have big plants. So, and it is prohibited for under 18-year-olds to do any of this propagation. So, back to the slide I had at the beginning about why is this problematic. And we say it's discriminatory on its face, it's a disproportionate impact, it ignores negative health consequences of criminal justice system involvement, and it's contrary to the YCJA. I'm going to turn to talk about the details about why we are concerned about these particular issues before we talk about the provincial legislation. And part of the reason for doing that is that I think the provincial legislation is not as vulnerable to these concerns as the federal legislation is. So we've sort of set our focus on the problematic aspects of the federal legislation. Does anybody have any questions about the federal legislation? I know I've just given you a tiny, tiny snapshot. Yeah?
I'm just going to ask about, so when it says like under 18 you can have less than 5, are they legally allowed to smoke it as well? Like, how are they allowed to have it, but at the same time they're saying all these things about how it's protecting young people's health? It's just kind of contradictory. I'm a little confused on that.
We'll call you as a witness when we get before the court someday. But no, I mean, this is one of the things, right? If it's really harmful to your health and we need to protect you, then why do we let you have what is, you know, not an insubstantial amount? And what's the distinction there? How does that, being able to have only 5 grams at a time as opposed to having 30 grams at a time, how is that really affecting its purpose? Yeah. Yeah, so this is one of the things we said is that there's, you know, conflicting kinds of legislation. So that is an important thing maybe before we go forward to make very clear. So the criminal law says that if you're 18 or older, you can have 30 grams and not be subject to criminal sanction. If you're 17 and younger, you can have 5 grams and not be subject to criminal sanction. The provincial legislation says if you are under 19, you can't have any. Okay, but the provincial sanctions are fines and referrals to programs, which we'll talk about a little bit later. So the sort of the jeopardy or the consequence or the punishment is much less substantial in the provincial law than it is in the federal law. Yeah.
What about people in the dwelling house? What's possession if there's an adult and 2 teenagers? How do you split the possession?
Yeah, well, this is a very interesting question. So, you know, if you were a parent and you happen to have 30 grams of cannabis in your house and the police come in and search and it's found in your child's bedroom, you know, that will be the question. Who is the actual possessor of this cannabis? And that will be a complicated thing for the courts to be working out. There's nothing in the legislation itself that will help define that. You know, the courts will look for what the law broadly says is indicia. So, you know, it was in my child's bedroom in the bottom drawer under the socks. you know, is that, you know, under a lock that only that my child had a key for, I didn't have a key for it. That might look more like it belongs to my child than, you know, the one that's in my bedroom, in the cupboard, in a, you know, whatever. Or what about if it's just in the kitchen cupboard with the, you know, rosemary, whatever. So these will be difficult questions. Yeah. So is that clear about, I mean, clear as mud about the difference between the provincial sanction and the federal sanction? Okay. So, I mean, some of this stuff may be intuitively apparent to you, but I really would be interested in your feedback and your commentary as well. So, discriminatory on its face. You know, in the olden days, when one group of people were not allowed to do something, but everybody else was allowed to do things, we called that, you know, discrimination. And the other thing we called it is a status offense. So, you know, one of the places that status offenses used to exist was for people experiencing poverty. You know, if you were poor, you weren't allowed to hang around in the train station, but if you were rich, you could hang around in the train station, that kind of thing. And here, we're saying that the status offense is that if you are a teenager, and I'm using teenager as the short form for people 17 and younger, but you are only allowed to have a small amount of cannabis in your possession, whereas if you are one day older, you can have a much more substantial amount of cannabis on you. And so what this means is that teenagers are subject to greater criminal liability than adults are. So the extent to which we have decriminalized cannabis is more for adults than it is for young people. We say that laws that discriminate in this fashion can be found to violate the Charter of Rights and Freedoms. And so our argument would be that it's discrimination on the basis of age to have a different criminal law standard for each of these groups. Well, there's no criminal sanction. I'm sorry I'm answering in English. I just trust myself much better. There's no criminal law sanction for the possession of alcohol. It's provincially regulated, and so you can't be taken to criminal court and face a possible jail sentence for drinking alcohol. But in the criminal law context for cannabis, you could be. Okay? Yeah?
Just a clarification question. So I understand that you can possess a certain amount, but then it's the distribution to the young people that's also criminalized. So how would you end up with a possession? The young people among themselves are not allowed to distribute, and the over 18s are not allowed to distribute to the young people.
This is another really, it's God's own personal mystery is how I feel about that. And the other reality is that under the provincial legislation, there are also restrictions not just to under 18-year-olds, but to under 19-year-olds. So you can't, in Ontario, people may be aware that there will be stores that are at least currently planned to be provincially run and managed, like the LCBO, where you will go in and you can buy cannabis. And so in Ontario, if you are not 19, you can't go into that store and you can't buy cannabis. So Mona's question is, how are you ever going to wind up with, you know, possession of, with legal possession if you can't access it? And that's one of the sort of inconsistencies in the legislation. But the reality is that if you somehow illicitly got cannabis, you would be subject to the provincial law, but you wouldn't be subject to the criminal law if it was less than 5 grams. Yes?
So if I was an 18-year-old trying to get around this, I could learn responsibility and grow my own plants?
If you are 18, you can have up to 4 plants in your household. So if you are 4 18-year-olds living together, you can still only have 4 plants in the household. That's how the law looks to me. Okay? Did you have?
No, I was just going to defend the legislation and say that obviously it's going to be illegal for teenagers to buy any cannabis, although they'll probably get it from the illegal market. But the idea is to play a harm reduction strategy in the hope that we're not criminalizing teenagers through possession of even illegal drugs, right?
Yeah, so did everybody hear that? That, you know, one aspect of the criminal law is it's trying to say, you know, even though it's not, you don't have access to it in a legal way, you know, let's not criminalize people who do happen to have small amounts. And that is true, that the legislation does do that. And so we have come some way in terms of making sure that teenagers are not facing criminal law sanction for possession of less than 5 grams. And I will tell you that over the years, you know, I've been a lawyer for a pretty long time now, and teenagers routinely get charged for possession of marijuana, or cannabis, pardon me, in very small amounts. So I've had clients who have flakes in their pocket, right? Very small amounts. It doesn't often sort of get followed through with prosecution, especially in recent years. And in recent years, you know, it really depends on the police force in the municipality whether people are getting charged, but it does happen, or it has happened. Okay? And somebody else had their hand up. No? Okay. So, I mean, the significant thing here from our point of view is that we think that there's a charter violation on its face with the legislation. So, the disproportionate impact is less, so yes?
I'll ask my question. I just want to know, est-ce qu'il y a d'autres articles du code criminel qui va criminaliser selon l'âge? Parce que si on regarde, par exemple, les relations sexuelles, c'est pour protéger la victime de 14 ans, mais est-ce qu'il y a d'autres dispositions qu'on va criminaliser selon l'âge?
Yeah, so did everybody hear the question? Are there other criminal code provisions that make this distinction based on age? And the one you identified is the one that comes immediately to my mind, which is that in the context of sexual assault, there are a bunch of different distinctions based on age, and we can talk about that if people want to. So there are some provisions that are age-based, but they're not typically, except for the one you sort of mentioned, they're not typically age-based distinctions where you're criminalized based on your age. So the only other context is the age of consent to sexual activity, and it really is about the age of the younger person in that context. So it's not, it's criminalizing the older person, not the younger person. So there's we could have a longer discussion about that. But the age of consent to sexual activity is 16 for sexual activity with anyone, 18 for sexual activity with a person in a position of power. And if you are 12, the age of consent, 12 to 14, you have to be within 2 years of the person with whom you're engaging in sexual activity. So it's a bit complicated too, and we can talk more about it if people want to. But I hope it makes sense to say that there isn't a broad-based criminalization of teenagers for engaging in sexual activity. The law tries to create close in age barrier or boundaries that mean that young teenagers are not having sexual relations, who are not engaged in sexual activity with people who are much older than they are. Yeah?
But it's to protect the young person.
It is to protect the young person, but also the young person isn't protected by making them vulnerable to criminal sanction. So if you're 12 and you engage in sexual activity with somebody who is 19, the 19-year-old is subject to criminal sanction, but not the 12-year-old. You know what I mean? Yeah, okay. So sort of shifting then to the question of disproportionate impact. And you know, this is a bigger question, a bigger sort of societal question, but we know very clearly that young people, racialized people, people from certain kinds of communities, especially those experiencing poverty, Indigenous people, people with mental health difficulties, are more commonly subject to criminal sanction and police interaction than are others. So there is a disproportionate impact of the criminal justice system on certain people in society based on their characteristics, not on their behavior. So our concern about the criminal law power being different is that those who are overrepresented in the criminal justice system already will be additionally subject to the kind of police scrutiny and surveillance that makes them vulnerable to being subject to greater criminal sanction in this context. Does that make sense? Okay. The other thing is that we're concerned about the lack of community-based resources that address substance use concerns. And this gets into, there's an overlap with one of the future concerns that we have around, if we're really concerned about young people's health, is the criminal justice system the mechanism that's meaningfully going to address that concern? And one of the things that I would say that I am concerned about in a broader way is that we lack community-based resources for children's mental health. And we turn to the criminal justice system in order to get access to those resources. And I think that's a significant problem. And that this legislation won't help that problem, it will exacerbate that problem. Oh, sorry, and the other one that we've highlighted there is that there is evidence to make clear that, especially with respect to teenagers, criminalization does not deter use. It's been criminal all this time. People are using it, teenagers are using it. You know, ongoing certain levels of criminalization will not deter use. Yeah.
I was just wondering why you think that it will exacerbate the problem, because obviously the problem exists and there is a disproportionate impact already. What makes it worse with this piece of legislation?
Well, I think that our idea is that overrepresentation already exists, and that while we sort of talk broadly about decriminalization and legalization, and we, so we say, oh, cannabis is off the list, we're still going to focus on those people about whom we sort of fixate in the criminal law context already, and so they will continue to be more vulnerable to things that people will. So if the police turn a blind eye to, pardon me for saying this, but to the rich white kid in a BMW's have possession of cannabis now, that will continue into the future, even if they're above the 5-gram limit, whereas the focus on the young racialized person in a community experiencing poverty will be hyper-focused, and they'll continue to focus there. And where they might or might not choose to use the criminal law power, they will continue to use the criminal law power. It's a question. Will it exacerbate, or will it just continue the disproportionate impact that exists? But our sense is that as we sort of move toward this idea of decriminalization, we're still bound to use it as a hook to draw people into the criminal justice system. Okay? So previously it was an end in and of itself. Now it may not be that as much, but it will still be a hook to find other problems and other reasons to criminalize. Does anybody else want to say anything about that? Yeah.
Don't you think that the education that should be combined with the, decriminalizing and, in terms of public health, in terms of, making sure that the substances are more adequate, are of better quality? Do you think this put together might help and not put as much as risk the young than before?
Well, that's another, so I hear your question in a couple of different ways, is that the education piece, won't that be important for protecting health? And I would absolutely agree that the education piece that will come along with new legislation, trying to get the message out there, what the effects of cannabis actually are, are there people for whom it's more dangerous than others, that kind of discussion in the, in the community broadly, I think those are always good things. Education is a benefit, I think. And the quality control question is another important thing. And I would say that the quality control aspects of the legislation, it's not something that I am very, very well educated about or extremely knowledgeable about, but that also seems sort of intuitively obvious to me that, we provide quality control, to fruits, vegetables, and meet, and we provide quality control to alcohol, and providing quality control to cannabis and THC, that also seems like a very good idea. And I think it probably will contribute to the health outcomes for adults and for young people. Yeah. Okay. So this is sort of a good segue maybe from your question. The next concern that we have is that, and I'm getting a little conscious of the time, so I'm going to try and move it along a little bit, but I don't want to discourage your questions, is that criminal justice system involvement also has a negative health impact, a negative social determinants of health kind of impact for young people. And the majority of young people have one intersection with the criminal justice system and no further intersection. But there is no question that vulnerabilities in society, such as being involved in the child welfare system, such as being racialized, experiencing poverty, those things all have a greater likelihood that you will be criminal justice system involved, and that you will continue to be criminally justice system involved. And so, there's disruption to school, there's disruption to family and community, there are, other physical health impacts, exposure to, to negative circumstances such as being incarcerated. All those things are negative in really concrete ways. And then there are less concrete things like the ongoing existence of a police record, like reduced focus on community-based resources to favor criminal justice system resources being available. The sort of sense of injustice that young people experience and the impact on their sense of social cohesion or sense of social belonging. All of these things are at play. And one of the things that I would say from my own experience, which is I would acknowledge is a little bit specific, but is most of the teenagers that I run into who are heavily using cannabis are doing so in what I would say are sort of self-medicating ways. It's often related to other kinds of health or social issues that are difficult to manage and are not being addressed adequately. So the other thing that I would say is that continuing to criminalize cannabis possession more than it is criminalized for adults is kind of contrary to the YCJ and the principles of the YCJ that seek to keep people out of the criminal justice system, in particular keep them out of custody. And I would say that simple possession of cannabis, like if you are 17 and you have 6 grams of cannabis and you get criminally charged, unless there's a lot of other stuff going on, you're not likely to go to jail. But it's possible, and so we have to be mindful of that kind of situation. But there's a failure to limit criminal justice system involvement, doesn't sort of inherently address the underlying causes of behavior, doesn't provide extra rights protection, and then the confusing messages that we've talked about sort of repeatedly. So ineffective and inappropriate approach to teenagers, and the big overarching thing here, which I think, the details are important, but, cannabis is illegal now. And the fact that it's more or it's less criminal now is not in my view, and I don't see the logical extension to suggest that it will be, that teenagers will reduce their use, simply because now there is a licit way to get cannabis, except that they don't have access to that, decriminalized market. So young people are still going to use the illicit market. It's still going to be underground, and it's still going to foster, in my view, the sort of underground drug trade. So I think, creating this distinction is problematic in the sense that it doesn't meet what the criminal law says is its main objective, or one of its main objectives, I should say, which is to sort of eliminate or reduce the illicit market. one of the things that I think is interesting that I've only heard a little bit talked about in the discourse is how, you know, alcohol used to come from an illicit market in a few different places, especially in the US. And after prohibition ended, you know, governments and society seemed to learn to deal fairly well with transitioning from an illicit market to a legal market. And I don't understand why we don't think the same things will happen in the context of cannabis, where we can move from an illicit market to illicit one and figure that out in a fairly comprehensive way and still limit, you know, teenage access to harmful substances without making it criminal. So I think there's some interesting stuff there. I think we've kind of talked about all of those things. So I've included a couple of slides, and I'm going to move more quickly so we can talk a little bit about the provincial law. One of the things I've listed here, the sections of the United Nations Convention on the Rights of the Child that I think are not addressed by differential treatment in the criminal law. Non-discrimination. Article 3 of the UNCRC says that we have a duty to care and protect well-being and health. And, you know, so my primary concern there is that if we acknowledge that criminal justice system involvement is not good for your well-being, then having remaining circumstances there where we criminalize young people to a greater extent than adults doesn't fulfill our obligation under the UNCRC there.